There is a tension at the heart of statutory interpretation. On the one hand, the purposive approach tells us to look to the purpose of the statute and then to interpret the statute to give effect to that intention. At the same time, when the Parliament makes legislation, it uses actual and specific words. It doesn't just give a vague expression of intention, so those words have to mean something too. This leads to a tension when the words themselves seem to mean something inconsistent with our understanding of the Parliament's intention. When the text of the legislation and the intention of the Parliament are at odds with one another, which should prevail? SM, a minor at the time of the alleged offending, committed certain offences, and the question before the court was whether a judge alone could find that SM was unfit to be tried, or whether this required a jury. Answering that question turned on the interpretation of the statute. Justice Weinberg found himself with the casting vote after the other two judges disagreed, and so Justice Weinberg undertook an extensive exercise of statutory interpretation. He found that whilst it might be sensible as a matter of policy for a judge alone to be able to determine a person's fitness for trial, and while it was very possible that the Parliament might have intended this to happen, the words of the statute were very clear and required a jury to decide the question. In undertaking this exercise, His Honour referred to what was then the recent approach of the High Court. He said, "The fact that the High Court now regularly reminds courts that the process of statutory interpretation requires them to focus first upon the structure and text of the Act, and to move to broader contextual matters only at a later stage, most definitely does not mean that these purposive considerations can be ignored. However, the emphasis in statutory interpretation does seem, in recent times, to have shifted somewhat. It might be said that the current approach to the interpretative task requires courts to both begin and end with the text. This case then gives us a key reminder that the purposive approach to statutory interpretation is not an invitation to simply ignore the words of the statute. If the words of the statute are clear, they must be given effect. We begin and we end with the text."